Senator Kennedy.
Thank you, Mr. Chairman. Judge, Counselor, congratulations. I want to be sure I understand your records. We'll start with Judge Cruz. Judge Cruz, you handled a case called ViaNet Operating Group v. Maurice. Is that right?
That's correct, Senator.
And you were reversed in that case. Is that right?
Yes, Senator.
You handled a case called Moodin v. University of Colorado. Is that right?
I believe so, Senator, yes.
And you were reversed in that case, right?
I believe a portion of my recommendation was reversed, yes.
Okay. Did you handle a case called Vreeland v. Vigil?
Yes, Senator.
And you were reversed in that case too?
A portion of that was reversed as well, yes.
Okay. Did you handle a case called Vreeland v. Olson?
Yes, Senator.
And were you reversed in that case too?
A portion of that was reversed as well, yes.
Okay. You handled a case called Key Bank National Association v. Williams. Is that right?
Yes, Senator.
Were you reversed in that case?
Senator, I've issued over 1,500 recommendations and orders over the course of my 4 years on the bench, and that is one that was partially reversed, yes.
Okay. You handled a case called Renault v. Cardenas. Do you remember that case?
Yes, Senator.
And you were reversed in that case too?
A portion of that was reversed as well.
Do you remember a case called Janney v. Gomez?
Yes, Senator.
And were you reversed in that case?
A portion of that was reversed as well, Senator.
Okay. How about a case, do you remember this case, Judge? Schwartz v. City of Denver?
The name is familiar, Senator. For all the cases I've handled, I'm not recalling particulars about that case.
Okay. Do you remember being reversed in that case?
Senator, I'm not specifically recalling that case.
Okay. Do you remember a case called Lucas v. Board of Commissioners of Larimer County?
The name is familiar, Senator. The details of the case are not coming to hand at the moment.
Do you remember being reversed in that case?
Senator, I don't recall offhand at the moment with that case.
Do you remember a case called Brooks v. Colorado Department of Corrections?
Yes, Senator.
Were you reversed in that case?
I'm not recalling offhand if that was one where I had a partial reversal.
Okay. Do you remember a case called ACV Jefferson County School District?
Yes, Senator.
Were you reversed in that case?
I was partially reversed in that case as well.
Okay. You remember a case called Blake v. United States?
The name sounds familiar, Senator.
Okay. Do you remember being reversed in that case?
I don't specifically recall that particular case.
Okay. Well, I've got others here. Cases that you handled in which you were reversed. Tell me why you've been reversed so often, Judge.
Well, Senator, as I indicated, I've issued over 1,500 recommendations and orders over the course of my career. When I approach any of these cases, I approach them all in the same fashion, which is to analyze the law, analyze the Supreme Court and 10th Circuit precedent that bears on those cases, and I apply those cases to the law or to the facts of that case. As a magistrate judge, many of those are recommendations that are made which are reviewed de novo. I respect the decisions of those district judges who viewed those circumstances differently.
Okay. Thank you, Judge. Tell me how you analyze a Brady motion.
How I analyze a Brady motion?
Yes.
Senator, in my 4.5 years on the bench, don't believe I've had the occasion to address a Brady motion in my career.
Do you know what a Brady motion is?
Senator, in my time on the bench, I've not had occasion to address that, and so it's not coming to mind at the moment what a Brady motion is.
Do you recall the U.S. Supreme Court case, Brady v. Maryland?
I do recall the name of the case, Senator, yes.
And what did it hold?
I believe that the Brady case Senator, I believe the Brady case involves something regarding the Second Amendment. It is not. I've not had occasion to address that. If that issue were to come before me, I would certainly analyze that Supreme Court precedent and apply it as I would need to the facts in front of me.
Thank you, Mr. Chairman. Mr. Papillon, tell me the definition of a motion in limine.
Motion in limine, in some law books it doesn't exist, Senator, but what it is it is a motion filed in advance of trial to get a ruling in limine, which means in advance of some issue that may come up in the trial, usually an evidentiary issue.
I thought you might know.
Thank you.
Judge Herson, explain to me the various definitions that the U.S. Supreme Court has used to define a fundamental right.
In Glucksberg, and even recently in Dobbs, the Supreme Court has really focused on two major issues. One, whether the right in question is deeply rooted in our history and tradition. And the court is also focused on whether it is implicit in the concept of ordered liberty. And I also believe that in Glucksberg they describe the need for the right to be clearly defined.
How does that relate to the discussion in Griswold of a penumbra?
Well, obviously, Griswold, as you state, points out this concept of the penumbra, rights that are not explicitly enumerated, but that the court has otherwise found. As a sitting magistrate judge, and if I was fortunate to become a district judge, I would, of course, follow the guidance of the Supreme Court, who has identified just a few, relatively small number of those rights. Obviously, the right to privacy, perhaps being the most well-known.
Well, can you have, what has the Supreme Court said about the existence of a fundamental right that is not part of our history and tradition? For example, when the court delved into the Second Amendment, it was really, the opinions were almost written as if they were historians as opposed to judges, but part of our history and tradition was a fundamental part of their discussion. Does the right have to be part of our history and tradition to be fundamental?
Well, I can say this, that in Heller, McDonald, and Bruin, that was the focus. That's what the court looked at. Now, there are other cases throughout history that have recognized a few other rights, the right to marry, for example. And I can't speak to the specific methodology that was used, but I will say, at least in the Second Amendment context, that focus on history was critically important.
Okay. All right. Let me move to Mr. Daniel. Can a police officer well, let me try this another way. If I'm walking down the street and a police officer wants to stop and talk to me, can he just stop and talk to me for any reason?
Senator, you can seek your consent to stop and talk to you.
What if I don't consent?
If you don't consent, then the officer needs to have a reasonable articulable suspicion that a crime has been committed, will be committed, and be able to articulate that to justify the stop.
Okay. Then how come police officers can set up a roadblock and stop 500 people to see if they have liability insurance?
My understanding is that the Supreme Court has ruled that those types of stops, when generally applied, are conducive to good order and policing.
Why? They're still stops, aren't they?
Senator, in my 8.5 years as a prosecutor, I've not had to litigate the adequacy.
I know. I'm just asking you what you think. I mean, isn't that pretty intrusive? What if I'm in a hurry to pick up my kid from school and I don't have time to wait for 10 minutes? And I don't want to wait anyway. Why? If a cop can't just stop me on the street, why can they stop me and check my insurance?
Senator, as far as my personal belief, I haven't encountered that.
I'm just asking you legally, why can they do that?
Again, I haven't encountered that issue, so I don't have the research on that, Senator.
Okay. Thank you. Thank you, gentlemen.
Absolutely. Thanks to all of you for being here today. Judge, Mr. Papillon, let's start with you. Got ahead of myself there. Tell me about the Erie Doctrine. What's your understanding of that doctrine?
Thank you, Senator. The Erie Doctrine is a doctrine that when a federal district court is sitting in diversity jurisdiction, it applies state substantive law and it applies the federal procedural law, the federal rules of civil procedure, the federal rules of evidence.
What's worse, in your view, invalidating as unconstitutional a statute whose unconstitutionality is sketchy, or upholding a statute whose application is in fact unconstitutional?
That's a difficult question, Senator. It obviously, if a law is unconstitutional, it is inappropriate and is something that should, going back to Marbury versus Madison in a different context, obviously.
Suppose we're talking about an as-applied challenge. It'll make it a little simpler.
Yeah. Can you tell me what you're asking?
An as-applied challenge, meaning it's you're not dealing with something that's facially unconstitutional. So what's worse in that circumstance? Upholding the application of a statute as to which it might be an unconstitutional application and is, or improperly holding something unconstitutional as applied when it's not. Is either one more defensible than the other?
I don't believe either is defensible, so it's hard to, when things are indefensible, it's hard to rank them. So I would say they're both wrong.
Yep. A few years ago, there was an executive order issued by Governor John Bell Edwards dealing with COVID in a lawsuit involving Pastor Tony Spell. The pastor argued, among other things, that he was protected by the First Amendment and that the law shouldn't apply, couldn't apply to his decision to hold church services. When you were asked about this at oral argument, you were reported to have said, quote, "The law is not about one person, whether a pastor or a churchgoer. We're a nation and a state of laws." Would you make that same argument today? Yeah, or was that, did you in fact make that argument?
That sounds like a familiar argument. I think I would argue a lot of things differently, I think, in that particular case. That was a very difficult and challenging case for the state of Louisiana and for religious liberty, Senator.
Okay. You said that sounds like a familiar argument, sounds like something you might have said. In other words,
yes.
Why is that appropriate? I mean, the First Amendment is there almost entirely for people making the argument as just one person, as the challenger. The whole reason we even need it is because it's there to protect people in expressing unpopular beliefs, in believing unpopular things. And so I don't understand why you would think that was a good argument to make, that the law isn't about one person. We're a nation and a state of laws. I mean, that's the whole point, is to, in some circumstances, penetrate the law to protect the individual, is it not?
Senator, in that particular case, to add context, this was a case that the state of Louisiana brought against a man of faith during the pandemic.
Who just wanted to have church. He
Yes.
wanted to have church services, and you prosecuted him for that.
And there was an executive order issued by the governor at a time, as you're aware, when the Lukumi decision and the Jacobson versus Massachusetts decisions were not necessarily in that particular context the most helpful tools for states. And my role
Right, not the most helpful tools because they went against the state's interests.
in some contexts, but in other contexts, the Fifth Circuit, for example, used it in another way. And so when states were forming their response on the ground, it would have been wonderful to have, for example, the benefit of Tannen versus Newsom at the time that this prosecution was brought.
Okay. That part is concerning to me because it's the whole reason we've got them. It's the only reason we have them. Judge Hersom, what's the standard for diversity jurisdiction?
In federal court, the diversity jurisdiction. Forgive me, I pledge not to do that. In federal court, the parties need to be from separate states, and the amount of controversy needs to be $75,000 or more.
Okay. Thank you very much. I see my time's expired.